My name is Reverend Jas Sira. I'm the founder of Angel Moves Ltd. We are HHSRS trained, the same framework used by enforcement officers when they inspect your property. We're also NRLA trained in the Renters' Right Act, and I also hold a law degree. We work with over 80 local authorities across the UK. We'll deal with enforcement officers, housing inspectors, problematic tenants, and disputes and evictions on a daily basis. What I'm about to show you is taken directly from the government's own website, and we're seeing this happen every day. On the 27th of December 25, the UK government published major new enforcement and investigatory powers under the Renters' Right Act. The government states it is placing a new duty on councils to take enforcement action and enhancing their powers of investigation to make that easier. First, on minor non-compliance, a civil penalty of up to £7,000, serious or repeat non-compliance up to £40,000 per breach. The Act provides a power to require information from third parties such as banks, accountants, client protection money schemes, and an additional route to build cases against landlords. Enforcements of fines and penalties have already started and only just started making the headlines. Recent reporting revealed over £5.2 million in landlord fines issued, while 6 councils failed to disclose their totals. Birmingham City Council, the largest local authority in Europe, has already issued £450,000 in fines linked to selective licensing alone, up to £30,000 per property. In a widely reported case involving a letting agent linked to Chancellor Rachel Reeves, a licensing oversight was admitted, but beyond the civil penalty, the landlord also faced the risk of a rent repayment order of up to £38,000. So that was 2 separate financial exposures from one oversight. So having a letting agent does not automatically remove your liability. Many local authorities are under severe financial pressure. The government has placed onto them a new legal duty to enforce housing laws, especially to be free of Category 1 and Category 2 hazards under the 2018 Fit for Human Habitation Act and HHSRS rules. With Section 21 gone, tenants can now report repairs issues without fear of eviction. They now have been given many routes to raise concerns: the Landlord Ombudsman, local authorities, tribunals, and legal aid solicitors. And here is what many landlords do not know. Before you seek to evict a tenant, your property must be free of Category 1 and Category 2 hazards. If not, that constitutes unlawful eviction. Unless you have a properly documented risk assessment survey signed off by your agent and your tenant, you are at risk. There are 29 Category 1 hazards under HHSRS. Category 2 hazards also carry fines and penalties for initial and minor breaches, and as the government's own guidance confirms, for the first time offences. They do not even have to give you a warning. It could be damp behind tiles, a loose floorboard, inadequate lighting, a gas or electric meter cupboard not boarded up, no window restricted, minor things like that. The gap with landlord and agent understanding is that they are aware of the Renters' Right Act, but are missing what the government's website says. These powers will be available for breaches relating to the new Act and wider housing legislation. There are 18 different legal frameworks that enforcement officers can use to issue fines and penalties, in government's own words, to make it easier. We are aware of these as we deal with these officers on a daily basis. Many landlords believe that if their property looks well presented, recently refurbished, or professionally managed, it must be compliant. It is not necessarily so. Once enforcement officers begin to investigate your property, it's very easy for them to build up fines. They're trained to identify risk, however minor. Your letting agent is not a building surveyor or a housing inspector. Their routine inspection is a cosmetic walkthrough. What your agent sees on a routine visit and what a council enforcement officer measures are 2 completely different things, and you do not need an incident to take place for fines and penalties to be issued against you. The risk of it happening is reason enough for them to issue fines. Angel Moves is offering a free 30-minute Zoom consultation and to help protect your property and your hard-earned investment against financial penalties of up to £40,000 plus. We are starting to get inundated with cases, agents and landlords who need our help. These slots are very, very limited. The consultations are free this week only for landlords referred through your letting agent. And we showed you from your government's own guidance, enforcement officers have the power to walk into your agent's office and ask specific questions. Are your properties free of Category 1 and Category 2 hazards? Have you carried out a risk assessment on your properties? Can you show us evidence of this? Your agent has done the right thing by bringing this to you. Now you need to protect yourself. Book your free consultation today to ensure your free slot. If you have any questions, email them to us beforehand. We address all questions anonymously in the session because most landlords have exactly the same concerns. We look forward to speaking with you. The booking link is on the screen below. You can email us at admin@angelmoves.co.uk. Call us on 0121 387 5800 or on 07411 761 548 or visit us on www.angelmoves.co.uk or simply just book through your letting agent. We look forward to hearing from you soon.